supra, and in the light of discussions made in the foregoing paragraphs and bearing in mind the limited scope for interference while sitting in intra-court appeal, the conclusion of the learned single judge where judgment dated such and such rendered in WPC number such and such, we find no reason to differ from. In the result, this writ appeal stands dismissed, but in the circumstances, there shall be no order as to costs.
I agree.
Item number 2, WPC 19873 of 2023 and batch of matters.
Having found no substance in the contentions raised on behalf of petitioners, but for the observation made in foregoing paragraphs, taking into account the peculiar factual position of the matter with regard to deposit of huge amount of money towards application fees, with the aforesaid observation, this court disposes of WPC number 19873 of 2023 along with other writ petitions tagged therewith. In these circumstances, there shall be no order as to costs.
I agree.
I beg pardon, Lords. With
Yes.
your Lordship's kind permission, one matter, Lords, your Lordship listed on 7th and directed for listing it on 11th. Matter relating to merger of schools, stage operating. And your Lordship directed state to take instruction whether other appeals have been filed or not. Only this issue your Lordship directed.
That is before division bench.
Yes, this bench.
This bench.
Yes. May be taken up, your Lordship.
We'll see. Give us leave, we'll see.
I know you pardon my lord. The item number 19 regarding the state doctors matter. The state doctors that matter. The chairman of the OCMR is present today. But he will not be available from 10th April to 20th April. So any date may be fixed.
You just make an application.
Yes.
We will consider whenever the matter is taken up.
Lordship, I want to mention, it is a matter I have twice mentioned before, Lordship. That is a matter relating to the demolition of the pond around Chilka Lake. Lordship, my problem is that if the rainy season will come, I cannot repair my pond, Lords. I will not do any fish cultivation or prawn cultivation, but I will do my plantation only. For that reason, I want to do the embankment on the ponds, Lordship. I have mentioned this matter twice. In this case, Lord and Senior Counsel from Delhi also appearing, Lordship. Fix up only date.
Well, the appearance of senior counsel from Delhi is not at all relevant.
The problem is that, Lordship,
That you are not required to make a mention. There is no difference between senior counsel from Delhi and you. The matter may be important,
Lordship, that's the.
not the lawyer.
Your Lordship,
I mean,
Matter, item number 19, your lords. No, I want to, next week, I see.
All right, but the bench is.
My lord, I need pardon, my lord. My lord, this CMAPL.
Give your slip, we will see.
My lord, I have a urgent matter, my lord. I have an urgent matter. My lord, I have an urgent matter. Writ appeal, my lord, I'm mentioning for tomorrow because in a writ petition, the personal appearance has been directed, my lord.
All right, give.
God bless.
Personal appearance is tomorrow.
My lord, no, Monday. So I'm praying for tomorrow. Tuesday. Monday is a holiday, man.
So you want that to be on Tuesday?
No, tomorrow, my lord. I'm praying writ appeal to be listed.
Oh,
Man.
we will see.
God bless.
What is the practice? Why bail matters are placed for orders? Why not for admission?
Yeah, in fact, all these bail matters are always meant for us, not admission.
From the very beginning.
Yes.
What is the provision under the rules? High Court rules have you examined?
I don't know, because it's a practice, so we have never break them off.
Yes.
Item 1. Well, petition is languishing in custody since 25th February 2023, my lord.
Only.
My lord. And forwarded under,
25th of February.
my lord.
Yes, what have you done?
The forwarded under section 21C and 25 of our NDPS Act, my lord.
Huh?
NDPS Act 25C of NDPS Act, my lord.
Yes. Commercial quantity.
Commercial.
Sorry, sir.
Lordship may kindly call for the case.
No.
As per their, my lord, forwarding report, it will not come under commercial country.
Let me see.
They say that 300 bottles of cough syrup has been seized, my lord. Each 5 ml containing 10 milligram, my lord. So as per my 300 liter comes in 600 gram will become actually 600 gram. It will be
Come with the recent Supreme Court decision.
that they have been cited, my lord.
Then
I will examine that decision kindly.
where is the question of examining the decision? The Supreme Court says we have to follow. You may be right in your submission,
My lord.
but we cannot be incorrect.
A further decision may become kindly urgent to my lord. Kindly urgent, my lord.
Upon perusal of the accusation made in the FIR, I am of the view that the allegation against the petitioner is covered by Section 37 of the NDPS Act. Stop. The prohibited items that to have been seized from the possession of the petitioner of commercial quantity. Stop. The court does not have any reason to record at this stage a finding that the petitioner has not committed the offense, and in future he is not likely to commit such offense. Of taking into account the embargo under Section 37 of the NDPS Act, this application is dismissed. Yes.
The accused is a headmaster of the school and he is in custody since 18/1/24. 18/1/24.
What has he done?
Well, the allegation is that the student is of 12 years, girl students,
Girl.
a girl student. And she was called to the room, the office room, and there was some allegation of sexual assault. And the allegation is on 8/1/24 and FIR was lodged on 14/1/24. And your lordship kindly peruse the whatever has come out. In paragraph 5, we have stated that your lordship may peruse the CD.
Yes, sir. CD.
Case diary.
Where is CD?
But no, it might have been called for. I don't know.
CD has been called for.
They call for after receipt of the copy of the
All right.
petition. Your lordship, just whatever we know in the meantime, charge sheet has been submitted. That has been submitted on 13/3/24.
Then trial will be expedited.
But your lordship, kindly, there is no material against him. Kindly see, my lord, the 8/1 is the allegation.
I can understand. 8/1 is the occurrence.
Yes, but
The offense was reported on 14/1
14/1,
and you are in custody since 18/1.
18/1.
So delay, there is no delay.
Delay
such
means,
matter.
delay means, my lord, in that area, your lordship will find whatever the defense, some materials has come out. In the medical report, the doctor says he's not capable of having sex.
No.
That is, doctor has said this in the report.
The doctor may say in the evidence.
But
The doctor may come as defense witness.
and both the girl and the informant has refused to be medical examined. They have refused.
Yes, that is the law.
And your lordship kindly consider he is going to retire in June. In the entire career, nothing is there. He has no allegation, no antecedent, nothing is there. That your lordship kindly consider that.
I have restrained myself
and
from making any comments, but yes.
My lord, informant is a party also. If your lordship so like may send the notice to or also that your lordship may kindly.
Yes, or what is there in the?
No, statement is not it because it has been copied recently served upon us on 19 months only. So we have not called for the deadline notes. Also give me time. Also direct I can get the CD.
Earlier order was passed, calling for the case.
No. First time it has come, but it's a routine manner of getting the CD after service of the copy of the petition.
All right. Call for the case ready.
Lordship, any short date, lordship. In the meanwhile, my lord, informant may be given notice as it is required to.
Let us see. Let the diary come.
Kindly short date then.
4 weeks.
Item number 3.
Yes, what is there?
Because it has been listed for the first time.
Oh, yes.
So nobody is here, not 6 Ganja, not sugar Ganja. NDPS at
NDPS.
9 kilos 600 grams, but there is nobody to not move the petition.
It is below.
Commercial quantity.
Below commercial quantity.
No, so it was also kind of, there is nothing excepting this rejection of page 15. Last paragraph, peruse the record on 11/24.
It can be granted.
Less than commercial quantity is up to lordship, but.
No, it is not commercial.
No, it's not.
No, less than commercial quantity.
Less than commercial.
Yes.
Less than commercial, he is in custody since when?
Since not 11/3. No, 24. 11/3/24 only lost. No. There is nobody to move the application and
We are here.
Less than commercial quantity, I am not standing to very much.
What is the penalty, punishment?
Fine, this will be.
10 years.
Let's some involves commercial quantities. It's in the 10 years.
For a term which may extend up to 10 years.
In the first item. Small quality quantity.
Extend to 10 years.
May extend. So, also can, because in less than commercial quantity.
The patrolling party, a police patrolling party, is said to have intercepted the petitioners. Which vehicle?
Plus, it's a
Accent car.
car,
Petitioners car
except there is no OD02BC.
leading to recovery of 9 kgs 600 grams of ganja. So, the quantity of ganja said to have been recovered from the petitioner's possession. Is any criminal antecedent whether it has come?
In the order, it doesn't reflect, because I don't have a case that order doesn't.
Order doesn't reflect. The reason is apparently less than commercial quantity. What's up? In such view of the matter, the application is allowed and so criminal antecedent subject. Yes. Subject to criminal antecedent also. Yes, all NDPS.
No, this is not NPA, this is not, I think, 380.
380.
Yes, 454, 380. From a school.
Item number 4. What is the accusation?
During the holidays of the school, some battery, computer and other things were stolen.
And since
And those materials were recovered from it. That is why he was arrested. Not.
any antecedent?
That is not rejected in the order because there is no secretary. But I can say what in the order doesn't say that he is involved in any other cases. Because also say similar notes.
It is mentioned that there is no other criminal case. Is it mentioned?
No, not mentioned. Also same order also say subject to verification.
The-
Accident.
It is stated in the application that the petitioner is 23 years old. Top allegation pertains to theft committed in a school
Yes, but government school.
of computer monitor, solar battery and speakers from a school. Full stop. According to the prosecution's case, the stolen items were recovered from the petitioner's possession. Full stop. What is the sentence?
Yes, up to 7 years. No.
Please. Imprisonment for-
Imprisonment
for some-
for 7 years or 5 years. Tribal by the magistrate.
Considering the fact that the offense said to have been the petitioner is said to have confessed the girl. The petitioner is said to have confessed in his bill before the police. Stop. A plea has been taken in the application that though no such confessional statement was made by the petitioner, which has no petitioner before the police, which has no evidentiary value. Full stop. Next, considering the nature of accusation and other materials on record, in my view, case is made out for grant of a regular bail, particularly as the case is traveled by a magistrate. Full stop. Allowed condition. Criminal antecedent. Yes.
Item number 5.
May I please? Petitioner is in custody since 7/12/2023, my lord. Offense under section 395 and 27 Arms Act, my lord.
395.
My lord.
Very serious. So what have you done?
While the informant along with other my lord were returning to home, on the way, 6 to 8 persons, unknown persons, have committed the theft of his scooty and other articles. There are petitioners not named in the affair, arrested in one case, thereafter taken on remand in this case, my lord.
So in how many cases you have been?
One case he was arrested, then taken on remand in this case.
What is the allegation against you?
The investigation is still in progress now.
No, what was there in the FIR?
Yes, in the FIR it stated that while the informant along with the brother, they were coming, not these on some 6 to 8 unknown persons assaulted his brother, taken away 2 mobiles, gold rings, chain and other articles along with cash. And the petitioner was arrested in connection to the case under section 364, read with section 395. And thereafter, he has been not so far in this case.
So how his name emerged? He is in custody.
Yes, sir.
So how name? How his name?
Yes, only category already category is also produce I can say. So also grant me some time to obtain the category.
All right, he's there 4 weeks.
Both 6 and 7 were 5 and 6 and one. So
You are in 6 also?
Well,
4 weeks.
Yes. 5 and
but in the item number 6, my lord, some of the co-accused person has granted bail, my lord. I have annexed the bail order, annexed 1 series, my lord, at page from the page 8, my lord.
That will apply in case number 5 also.
No, my lord, it is a different case. Same offense, different case.
GR case 1807, there also GR case 1807.
The
And PS case is 295 in both cases same.
197.
Both cases. You have written it on the very first page.
Any confusion?
My lord, some.
Some
I will
con-
verify this one.
Why did you say that? Let us see where is that. In item number 6, you were referring to some order passed by. With what?
I have wrong file with me, ma'am.
Yes, got the outside.
Next.
Item number 7.
720 B2C of the NDPS Act. I filed a memo stating and not paste the application. 150 kg of ganja. Final PR has been filed.
So you are not pressing.
We are not placing.
And counsel for the petitioners does not intend to place this application. Application for bail is accordingly dismissed as not pressed. You played a lot of holy, no?
Item number 8.
It is a case under section 52A of the Odisha Excise Act, my lord. The tribal by master offence, my lord. Tribal by magistrate, my lord. That is that offence, my lord. And the already charge sheet filed on 10/3/2024.
Where is the punishment?
Under 7 years.
Huh?
Under 7 years, my lord, that there is there. In already. I have annexed that forwarding report where that I have already stated that yes, 41 notice was issued, but as the petitioner could not compare that bail, he could not be arrested. Already charge sheet filed on the 10/3/2024. Which custody since 28/2/2024.
What is ID liquor?
Glass, illegal distilled glass, illicitly distilled glass.
Eleven hundred liters.
1,100 liters of ID liquor. Rejection ground is investigation is going on. And the petitioner belongs to state of Jharkhand, belongs.
It is that is permanent resident of Jharkhand. Now she is residing. Now she is residing near under the jurisdiction of the Bargad police station.
But 1100 liters is huge quantity. That to ID.
Already charge sheet filed.
Charge sheet has been filed.
Right.
Then at the trial quantity.
Tribal master offence already custody since 22/2024.
No, nothing.
41 notice was issued, but it could not comply that bail, my lord. For that reason,
But 1100 is to huge amount.
that's 3 years punishment. 3 years to up to 7 years.
So what?
Punishment. Any condition, my lord, any condition.
No condition.
Any stage is not a
Not a mistake.
He was the pillion rider. Another person was the vehicle owner, was the another person. He was sitting in that vehicle, my lord.
Sitting is enough. Vehicle owner may be released.
And another person, driver is the another person.
Yes. Sorry.
Any stage.
Considering the circumstance that from the petitioner's possession, that from a car,
Pardon me. Volunteer to withdraw.
and counsel for the petitioner after some argument seeks permission to withdraw this application with a liberty to renew his prayer for bail after 1 year. If in the meanwhile, there is no substantial progress at the trial. All right. 1 year.
Already.
6 months. 6 months.
Item 9.
Please, your lords. Alleged offence is under section 376, 323.
Just a
IPC. Pardon?
Just a minute. Yes. Why should you be granted bail?
But, first of all, Ballot, the victim is a married lady of 40 years old. she has falsely implicated him, this petitioner, the 21-year boy, my lord. The charge sheet has been submitted. He's in custody since 30/4/2023. My lord, furthermore, my lord, the and case has also been committed to the Court of Sessions. Now, my submission before Lordship that first of all, the FIR has been lodged belatedly, my lord. After 3 days of the occurrence, FIR has been lodged, and alleged that when his relation came to the spot and they found this. So it cannot be, my lord, even accepting the case, the consent of cannot be ruled out. He's 21 years old and he's a 40 years married lady, my lord. When their relation, this uncle came to the spot.
So you made two submissions. One,
Yes,
that the lady is 40 years old
my lord.
and you are only 22, 21. And therefore the accusation is false. And your second submission is.
No, I'm
that
not saying that this is
the
false.
came,
I'm not
he
saying
is-
false, my lord. The case, this it says falsely. Yes,
it can be ruled out,
and
not in 376.
no,
Wait for some time.
no injury. Pardon?
No injury.
No injury has been found.
What do you want?
Lordship, my call for the statement of the victim and injury.
Considering the Lord Counsel appearing on behalf of the petitioner has argued that the prosecution's case as disclosed in the FIR appears to be concocted for the reason that, firstly for the reason that the case was registered 3 days after the alleged date of occurrence. He secondly submits that the victim is said to be 40 years old, whereas the petitioner is hardly 21 years old. So he has thirdly submitted he has thirdly submitted that no injury has been found on the person of the victim. So next, none of the submissions convince this court for directing release of the petitioner on bail, considering the gravity of the offense alleged. So the petitioner is in custody since
28/4/2023. 28 April 2023.
28/4/2023. So in this application is dismissed, but with the liberty to the petitioner to renew his prayer for bail after 6 months, if in the meanwhile there is no substantial progress at the trial. Yes.
Item number 10.
Number 10, my lord. It's a dispute, business dispute, my lord. FIR has been registered for commission of offence under section 341, 323, 307, 506/34 IPC and section 25-27 of the Arms Act. Alleging that, my lord, a small FIR alleging that the informant has he was to supply, let's say business deal, they are supposed to supply vehicles, 200 vehicles to a particular company for unloading, my lord. Alleged that on the date of occurrence, this petitioner, they came and abused him and assaulted and threatened him on the point of gun. That is the allegation. No injury, my lord. Injury sustained, my lord. Injury report. I have also annexed the annexure 3 injury report.
Who is Ajit Dhal?
He is not the petitioner, my lord.
No, he is not the. Who is he?
He is one of the transporter. Alleged that this that person has, and we are the petitioner or the person of that person. That is the alleged. It is the.
Yes, what is there against him?
Accepting the injection order, I don't
I have separate.
No, FIR you must be having.
FIR is there.
So what is there in the FIR?
Allegation is that they threatened, of course, no visible
Injury.
injury, simple in nature. That is the report of the medical officer.
It is the prosecution's case that the informant, owner of transport company engaged in lifting of coals, lifting of coal, had to deploy 200 vehicles. Most of allegedly on the date of occurrence, that is 21/2/2024, when the informant was going to deploy the said vehicles, one Ajit Dhal and others came, started abusing the informant and threatened to kill him. Stop. The associates of Ajit Dhal, according to the prosecution's case, assaulted,
That assaulted.
pointed pistol towards him and attempted to kill him by throttling. So the petitioner is said to be one of the associates of Ajit Dhal.
Alleged, my lord, yes.
Next. And counsel appearing on behalf of the petitioner has submitted that no grievous injury has been found on the body of the informant. Of allegation against the petitioner is of general and omnibus nature. Next, considering the nature of allegation as emerging from the FIR and the submissions advanced on behalf of the petitioner as noted above, this application is allowed.
Blessed.
Item 11.
Yes.
Commercial, because there is nobody.
Commercial. What is there against her?
Since I was under section 20, the small b not to C, that is commercial quantity, total consumption 34 kilos.
No, but that was recovered from her possession.
But from his possession, it is specifically mentioned in the order.
No, his or her. His who?
Page 18 is also can come to the order. Page 18, paragraph 3.
She is a woman. The petitioner is a woman.
She must, I think. Yes, ma'am. 36 years old lady. Yes, from her person, because there are not 1, 2, 3, 4, 5 accused persons. And from there's one Kartik Hazara, 22 kilos. Tulsi Saspal, the present petitioner, 3 kgs. Pratima Bear, another lady, Mirror, 3 kgs. And Satya Dalchandra, 3 kgs. And another lady, Sabila Kumari, 3 kgs. And putting all together about 34 kgs. So
how can that be done?
Not individual case, they said that because they were going together, they was always been added and now 20 B to C has been lost, madam.
Based on a secret information, the police are said to have intercepted 5 persons, including this petitioner, leading to recovery of 34 kg of ganja in all from their possession. So, taking total quantity of ganja recovered from their possession to be above commercial quantity, the petitioner and other accused persons have been charged of commission of offense punishable under section 20 capital C of the NDPS Act. At 20B bracketed Roman 2 capital C of the NDPS Act. Oh, stop. From the petitioner's possession, 3 kg of ganja was recovered. So stop. Considering the circumstance that the amount of ganja recovered from the petitioner according to the prosecution was 3 kg and 3 kg, comma, this application allowed 3 kg, comma, in court's opinion, section 20 bracketed 20 bracketed V bracketed Roman 2 capital C shall have no application. This application is accordingly allowed.
Item number 12.
Submit the verification of yes.
Item
12.
12, 20B to C of the NDPS Act 75 kg. The only point, if your lordship, my lord, is it is intercepted by the excise department, my lord. Well, the intercepted, my lord, section 50 was not complied. But if it's my lord, substantially, my lord, it is not complied, my lord, because they admitted that they did not give any option.
That can be seen at the time of trial.
I can refer to the judgment of this honorable court, my lord, by the co-bench. They have, my lord, given the judgment, my lord, referring to the apex court judgment, that if it is not from the apparent from the record, that cannot be developed, my lord. It is admitted that he did not give any option to the executive officer or gazetted officer. He gave an option that to be searched before him. Thereafter, they search. He stated that he was interested to search before by the IO in detecting officer.
Is it correct?
That is there, my lord.
No, from the FIR.
FIR. What do you?
Just a minute, sir.
Yes.
From the FIR, whether you can show that at the time of search, he was given
To be sought by gated options.
Yes, option. He was searched by himself.
just a minute. Why, sir?
Running page.
Please wait. You know, we are also as interested in your client as you are.
As it's. I'm saying running plus 12.
All right, we'll call for CD.
No, better.
Next. 4 weeks. 4 weeks. 4 weeks.
Item 13.
13, my lord. So case is under section 294, 323, 307, 384, 506 by 34 IPC. My lord. That case is like this, my lord. The informant is the son of the injured. What he alleged that on the date of occurrence, first he committed theft of a mobile phone of the present petitioners. Alleged that with both the petitioner, they took him to their house and assaulted and said that you have committed theft of a mobile phone and stated him to return back because he has sold that mobile. So thereafter, on the next day, while he was on the market, he was humiliated by two persons, one Gangu Samal and Bana Samal. That you are, and they humiliated that you have committed theft, and that is why you have been assaulted. So he attempted to commit suicide by pouring kerosene. So that is why we are in custody since January. They have not also, for that reason, 307.
And what is the reason given by the district judge for rejecting your
Case 14, paragraph 5. There will be record. Statement of witness recorded under section 1 sequence injury report. Up to date CD submitted by the IOP. The allegation leveled against the accused person under section 294, 320, 307, 384, 500, 511, 534 IPC. Out of which 307, 511 are executed trial by the court of session. On perusal of the material given by the accused petitioner assaulted son of the informant with the allegation of mobile theft and humiliated him.
dying declaration.
No, he is survived.
Just why have you picked up this habit?
I had to take instruction because it was recorded, registered under section 307 because he was undergoing treatment and statement was recorded. Whether it is recovered or the charge sheet has not yet been submitted. So if also grant me time, I can obtain instruction whether charge sheet has been submitted and whether it has been discharged from the hospital.
So what is there against him?
It seems not so. Because of the humiliation, he could not bear it in front of the public. That's why he attempted to commit suicide. That was the allegation against the petitioner that he was assaulted and humiliated for theft of a mobile. That is the allegation.
Is the prosecution's case as disclosed in the FIR that on the alleged date of occurrence, that is 12/2/2023, the informant's son, after having consumed liquor, was returning home. Stop. In the meanwhile, the petitioners, how many petitioners?
Two petitioner.
Dragged her inside their house and dragged him inside their house and assaulted him with an allegation of theft of their mobile phone. He was subsequently released with an undertaking from him that he would pay the cost of the stolen mobile phone. So stop. On the next day, the petitioners are said to have made uncharitable remarks against the informant's son, because of which he attempted to commit suicide by pouring kerosene oil over his whole body. Stop. Let counsel appearing on behalf of the petitioners. Petitioner number 1 is father of petitioner number 2. Learned counsel for the petitioners has submitted that the accusation made in the FIR, even if teacher to be correct, does not make out any offense punishable under section 307 of the IPC. Stop. The informant. Is there an injury report?
Injury report, I don't have my letter.
No. Next. I find substance in the submission made on behalf of the petitioner. Stop. Based on what is alleged in the FIR, no offense under section 307 of the IPC can be said to be made out. Stop. The court, it is unfortunate that even in such cases, the courts at the district level, the court at the district level has not granted the, has declined. In such, even in such a case, the additional district and session judge Soro has declined to grant or decline the petitioner's prayer for their release on bail. Stop. Next, this application is accordingly allowed. Absolutely nothing. What is happening?
Case notes under section 343 for assault of mobile phone.
Nothing. He was drunk.
Yes.
We don't know what. And there is no allegation of what kind of injury he had sustained. Yes.
Item note 14.
That on behalf of Mr. Manthi, some other date may be given, your lordship.
Why?
He on another court, your lordship.
Another court, he cannot afford that.
May permit to place.
Hmm?
I may permit to place, your lordship.
He cannot avoid Chief Justice's court to be there in some other court, Mr. All right.
I am
please wait.
placing you, Lord.
Please wait, please wait. I may give you time, may not.
I am a permit to place you. Lord.
Just. Can you read the FIR? What is there? 376 is not made out.
511. He says the petitioner came to the house of the victim lady and asked her that her husband had to accompany him to go to that they said that in a different state for this works. We say Dadon to work as a laborer. Some contract, we call it as your Dadon. Like that. The informant refused to that petitioner that his husband will not accompany him. So there was some altercation, and it stated that at that time this parent petitioner scolded her in Hindi language, misbehavior, and they were after tore his wearing apparel and attempted to commit rape. That is with 376, 511 law. And when she raised Nala, the petitioner ran away from the house. That is the allegation.
G76 charge sheet submitted.
Second, no. Recently the FIR has been registered.
No, charge sheet submitted.
I don't know whether it can say.
Yes.
That's it
Please
submitted.
come. Paragraph 4.
Yes, sir. Order sheet shows that it submitted under section 452, 341, 294, 320, 354B.
It appears. So the petitioner's husband, the victim's husband was to be taken on contract.
Yes,
My lord, both have taken money to work outside of the state. And on the occurrence day, they have to go with by bus, but they did not come. For them, ticket was also booked to go outside. But there is quarrel, your lordship. That is the theme of the case.
That 370 will be attacked.
My lord, there is, in effect, there is no allegation of 376. By pressing, try to press my neck is there, your lordship. Not attempt to commit rape allegation is there in effect. But subsequently that has been added, your lordship. My lord, in custody since your lordship 27/6/2023, your lordship.
It is the prosecution's case that the petitioner entered into her house when her husband had gone outside, abused her, and attempted to kill her and disrobed her too. So stop. Learned counsel appearing on behalf of the petitioner is right in his submission that no offense under section 376 of the IPC can said to be made out on the basis of what has been alleged in the FIR. So stop. He has also submitted that according to the FIR itself, the occurrence had taken place as the informant and her husband had declined to go for decline to accompany the petitioner for contractual work for which the tickets were also booked. Full stop. He submits that the accusation of sexual assault is manifestly false and malicious. So, considering the nature of allegation emerging from the first information report and submissions advanced on behalf of the petitioner, case is made out for grant of regular bail.
Item 15. Item number 15.
What is the quantity?
45 kilos, lots of ganja.
55 kg ganja. There are two reasons why this court is not inclined to grant the petitioner privilege of regular bail. Firstly, the recovery of contraband from the petitioner's possession quantity of contraband recovered from the petitioner's possession is more than commercial quantity, and therefore the embargo under section 37 of the NDPS Act applies. Secondly, the petitioner has criminal antecedents as is evident from the disclosure made in paragraph 9 of the application itself. This application is accordingly dismissed.
Item number 16.
May I please, your lordship? But the fair allegation is that, my lord, while the informant was about to travel in a bus, one person has snatched away his mobile phone. And here there are 7 petitioners before my lord. And while the petitioners were in custody in another case, they were remanded in this case on 12th January 2027.
12 January?
12th January 2024. And charge sheet has already been submitted in this case, my lord. And so far the recovery of the alleged mobile phone is that from the rejection order, it is found that that mobile phone has been seized from the petition number 3, that is Rahul Nonia.
One mobile phone was stolen.
Yes, one mobile phone.
One mobile phone.
One mobile phone.
By 7 persons.
That is the FIR allegation, but they confess that we are We have stolen so many mobile phones from different persons. That's why
They can.
they have confessed before the police. That's why all the petitioners have been included in this case also. Though allegation is that one person has snatched away the mobile phone from the informer.
The offense is triable by magistrate. The allegation against all the petitioners. Yes, madam.
This during investigation, it was found out that they belong to one gang, and it's a racket which is going on in Bhubaneswar town, and they have been stealing different mobiles from different people. And unless you know the antecedent, they all belong to one gang and they belong to state of West Bengal. So in case your lordship grants the FIR is not there. Probably FIR was against unknown person. He has not attached the FIR, and the FIR is not.
FIR you have not attached.
The eligible copy was not with me because that's why.
This is not done.
But from
Sorry. Without FIR, how can you file your bail?
From the rejection order, Miller.
No, we don't go by rejection order.
That is not eligible. That's why I have mentioned.
No, you'll have to, whatever.
My lord,
You don't get certified copies of the FIR.
Not true. Certified copy, which not.
Certified copy of the FIR you don't get.
I have not received that.
How can you file? Is there any requirement under the High Court rule? There must be requirement.
No,
May not be.
Because now we are required to file minutes and copy of the FIR minutes mandatorily. Each and application.
Without FIR, we cannot apply our mind. 4 weeks time is allowed to learn counsel for the petitioner to file certified copy. Certified copy of FIR. List this case on.
Within 2 weeks, I can obtain it to Bhubaneswar.
Huh?
Within 2 weeks, your lordship may allow.
2 weeks.
Item 17.
Twenty B 2C of the NDPS Act, your lordship, 25 kg of ganja has been seized from a vehicles, 4-wheeler vehicles, your lordship. Your prosecution case is that while the inspector of police was performing patrolling duty with other staff, got information about transport.
It is commercial quantity.
My lord, maybe commercial quantity here, the 42 and 50 NDPS had not been followed. And in this case, 5 accused persons are there, 3 accused persons in the car and 2 accused persons in a bike. From the car, the articles has been seized, your lordship. And before seizing the articles, the executive magistrate, the women, all were present and they were waiting for coming of the vehicle, your lordship. This is a totally false case, your lordship. Number of witnesses have been examined in this case. They have also stated that no such occurrence has been occurred at the spot which has been mentioned.
How many witnesses have been examined at the trial?
My lord, not trial, your lordship. Investigation is going on. Some persons has stated, your lordship.
We cannot go into that.
My lord, kindly call for the case diary. Kindly call for the case diary, your lordship. Kindly call for the case diary.
Why?
My lord, here the present petitioner is the driver of the car. And from the dicky, your lordship, that articles has been seized, they are saying. But your lordship, kindly gone through the FIR, your lordship. They got information about transportation. And on receipt of information, they called the executive magistrate, they called the women, they called the...
that can be seen at the stage of trial.
My lord, how...
Question is of...
But without detection, your lordship...
without?
the articles has not been detected. And they intimated the executive magistrate about the detection of the entire case is suspicion, your lordship. Before detecting the contraband article, how the informant or the police knew
You
that
can
such.
take this plea at the stage of trial.
My lord, kindly call for the case diary, your lordship. I will more things to argue in this case, your lordship. Kindly.
What more?
My lord,
What more can you argue?
my lord, 25 kilo, your lordship, ordinary range is normally allowing up to.
We go by law, Mr.
My lord, your lordship, kindly, therefore I am my.
As requested on behalf of the petitioner, list this matter on 2 weeks.
My lord, 24 also same case, another accused.
24 has been called.
No, my lord, same case, other two accused persons. That
Okay.
Item 18.
Item 18, I am appearing through VC, my lords. I may be permitted through VC, your lords.
Yes, please do.
My lords. My lords, my limited prayer, my lords. The matter may be disposed of granting liberty to renew my prayer after examination of the injured during the trial. Case of 307 and 326. The rejection order shows that
Come after some time. Ma'am. Cannot give you this liberty that you come after examination of particular witness. Come after 6 months. And counsel for the petitioner, after some argument, seeks permission to withdraw this application with the liberty to approach this court after 6 months. If in the meanwhile either there is no progress at the trial or any progress at the trial gives the petitioner a new cause of action to renew his prayer for bail. Stop. This application is accordingly dismissed as withdrawn with the liberty as sought.
Item number 19.
My lord, in this case, the petitioners were nowhere entangled in the case. My lord, they are the victim
What
of
is the
the.
meaning of entangle?
My lord,
What is
they are
the
the
meaning of entangle?
unnecessary they are involved, my lord.
Dictionary hai.
Unnecessary they are involved, my lord.
What is the meaning of entangle?
The meaning of entangle, my lord, differs from sentence to sentence, my lord. Here, my lord, they have unnecessary drag into a criminal case, my lord.
All right. Yes.
My lord, basically they are the victim of the circumstances, my lord.
All right.
In the FIR, nowhere their name has been reflected, my lord, and they are not present at the time of the occurrence, my lord, and they don't have any criminal antecedent also. If your lordship see my annexure 2, which is a rejection order of the learned trial court, my lord, kindly see page 13, my lord, of my bail application.
No, the violation is serious.
The offenses were serious offense, my lord. All are non-bailable offenses. But these two fellows were not involved. They caught from the car from which the robbery property was.
For the case diary.
Yes, my lord. Yes, my lord.
4 weeks.
Item 20.
Item 20, get it. Belgium matter. Belgium matter. Pursuant to the warrant issued by the learned court in session over the matter, the person was arrested and remanded. You also see at the date chart I have given, the person was arrested on 12/2/2014. And 12/2/2014.
10 years.
Yes, he was granted bail on 9/1/2015. On the date fixed, due to communication gap, non-taking of steps, NBW was issued, and by virtue of the NBW, I was arrested, put behind the bar.
When?
Which was on 9/2/2024.
20.
All right. Oh. The petitioner was granted bail. The petitioner was arrested in 2014,
Yes.
whereafter he was released on bail
9/1/2015.
9/1/2015. So, on the ground of misuse of privilege of bail,
Yes.
his bail bonds came to be cancelled.
No, it was not cancelled
Ah.
due to non-appearance and non-taking of step by the conducting council. Warrant of arrest was issued.
Non-bailable warrant
Was issued, and by virtue of the NBW, I was arrested, put behind the bar.
Unless your bail bonds, like, how can there be warrant of arrest issued without cancelling your bail bond?
Let's come to page 14, my lord.
Page 14.
Yes, my lord. Order dated 19/2/2024. That may I place it during course of hearing of the bail application.
Available warrant of arrest.
No, NBW was issued, my lord.
Okay. Now, on the ground of misuse of privilege of bail, as the petitioner failed to appear before the court below, a non-bailable warrant of arrest was
Yes.
issued on 9/2/2024. 9/2,
He was arrested on 9/2, my lord.
whereafter he was arrested on 9/2/2024. Stop. Next, learned counsel appearing on behalf of the petitioner has submitted that because of long pendency of the criminal case, the petitioner failed to maintain a track of the said case and could not appear before the court on regular basis. So stop. Next. Learned. Your public prosecutor. Public prosecutor. Learned public prosecutor appearing for the state has argued that the non-bailable warrant was issued in 2020.
Yes, 12 March 2020.
12 March 2020. 4 years thereafter, nearly 4 years thereafter, the petitioner was apprehended. So, therefore, he does not deserve grant of privilege of bail now. So, next. Be that as it may, considering the fact that petitioner was earlier allowed bail and he is in custody on the ground of jumping the bail, this application deserves to be allowed with the condition that if he fails to appear before the court below on 2 consecutive occasions, his bail bond shall be liable to be cancelled.
Nice.
Item 21.
Item 21. On web, Mr. I pray for next week. I pray for adjournment, madam.
Hey, I can grant in bail in second case also.
No, that is not my case. One Mr. Misro is there.
Still, all right. Let me see. Yes, what is the quantity, ganja? 9.
14 kilos, 390 grams.
less than commercial.
No, but there are two motorcycles. How many motorcycles were there? Two or one?
One, motorcycle and scooty. Three persons were apprehended. Rujatan Katwa, Sandeep Katwa, Nachudas Katwa. So present petitioner is Sandeep Katwa.
From him, 9.2. 9.270. He was riding which motorcycle? TVS OD 27C. Which motorcycle? From the possession of three persons, including this petitioner, the police are said to have recovered a total of 14.390 kilograms of ganja. Full stop. All the three persons named in the FIR were riding three different two-wheelers. Full stop. Could you get something? And who was?
Oh my God. Omnigo's allegations, another all of them.
Full stop. Considering the amount of ganja said to have been recovered from the possession of petitioner, this application is, which is much less than commercial quantity. The application is allowed. Condition antecedent. Yes.
Item 22.
Subject to verification of the antecedents of crime.
Yes.
Petitioner in jail custody since 4/9/23, offense on section 376(2)(n), 363, 366 IPC and 6 of the POSCO Act. Prosecution case is that the petitioner kidnapped the victim from her house and took in the temple and married in the temple. Thereafter, came to
What was the age?
age is the 17 years, while victim is denied for medical examination.
For what?
And the victim stayed at the petitioner's house some days. Thereafter, the petitioner went to Kerala for a job. When the victim contacted over a phone, the petitioner did not respond. Then the victim came back to his parents' house and lost the affair. This is the prosecution case. And the 164 sheriff statement is clearly mentioned that there is no, absolutely there is no physical relationship with the petitioner. No help mentioned. 164 CRC has not alleged regarding commission of rape.
The eviction order says that the here also FIR copy is not.
FIR, why are you not including FIR? No, FIR was all.
Certified copy was not available, that's why I could not file.
This case on 4 weeks. This practice will have to stop.
Yes, I will file.
4 weeks time is allowed for the petitioner to file a certified copy of the FIR.
2 weeks time.
2 weeks.
Item 23.
One Passover, that one Passover.
Where FIR is whether
Yes,
there.
yes, FIR is there, yes. Just like last case, Mr. Mahanti is on the way.
Yes, I'm waiting.
Yes, yes. Diplomatized.
I'm waiting for him.
No, my lord, that's one person. One person, sorry.
Do you have the file with you?
Yes, yes, my lord. Whole allegation against me, my lord.
Whether the amount was.
No, no, that is absolutely false, my lord. The 71 lakhs not in my.
Paid through check or what?
Yes, sir. I'm no through check. That the past agreement dated in the year
Just a
2016
minute. So you had received the amount through check.
through RTGS.
Oh, RTGS.
Yes, ma'am.
And you have not executed the sale deed.
Diplomatized.
And this is a civil dispute.
Diplomatized.
Whether you will pay the amount or not.
My submission before your lordship that as per the allegation against me, lord, that the amount is concerned the 71 lakhs and somewhat not in my account, only 16.20. Admittedly, one agreement in the year 2016. I am received that 4.5 lakhs, it is annexure 3.
Forget the amount.
Execute the sale deed.
Execution of sale deed.
Yes,
Whether you had received any amount or not.
Yes, lord, absolutely.
How much?
4.5 lakhs, lord, at the time of agreement, lord.
And thereafter?
Thereafter, another 5 lakhs. Thereafter, 6.5 lakhs. That's not, lord. I am against 16.20. Your lordship directed to deposit the entire amount before the lower court is a fixed deposit account. Then I'm.
Where is the lower court? Some matter is pending. This criminal.
That on the I am 80 years old man, lord. That now I am suffering my diseases, lord. I am ready to pay the refund my amount. In the year 2022, some RTGS in my account, lord. After a period of 6 years, lord. And this informant also challenged my sale deed.
So this 63,000 lakh you had not received?
No, absolutely not, lord. Absolutely no.
This was paid through cash?
No, my lord. That through RTGS, man, two transactions is there through RTGS. That is on record, lord. That one bank statement of that. Not in the company, lord. That not the informant's account. That is the company account, lord. I am only received the 5 lakhs and thereafter received the 6.5 lakhs.
Mr. Senior Counsel has come.
Yes. That.
Altogether, your lordship asked me total how much I have received. I have received 16 lakhs 20,000.
See, you, Mr. Mohanty, you don't have to make a submission. That's a purely civil dispute.
Yes.
And therefore,
that is true.
Has been given a color of criminal case.
And
but the court is interested in your honesty also. If you have received any amount, pay that to him.
16 lakhs 20,000 we have deposited. I have received. Other, your lordship will find from the agreement that there are 5 co-sharers. They have also received money. They are separately as accused. They are moving their application. But the trial court's finding that I have received 71 lakhs rupees, that is not correct. That is
then let all of them come together.
Well, that is, we are not appearing for them. They have taken the money. They are not.
So they are not in jail.
No. One person is in jail. Another has moved. I am given to understand. I was inquiring that he has given filed anticipatory bail application, and other 2 was not known.
So if all of you come jointly, then I will consider.
But it is difficult.
Otherwise, this will.
We are not.
Litigation will continue unnecessarily.
16 lakhs 20,000. I am ready to pay. Ready to deposit. I am an old man of 80 years. But my nephews and
they are all witnesses to the. He is the sole executant.
That is right.
He is the sole executant.
Whether any criminal case is made out, whether any offense is made out, on the basis of,
Because instead of handing over the land to him, he was trying to sell it to somebody else.
that is not fraud. That is when he received the money, he was competent to execute. Now subsequently, he decided not to execute. It's a civil dispute. But still, he is ready to pay. Let us see.
I mean, as the Lordship was suggesting, let all of them come together.
When they will, my lord, they will come when I don't know. I have been arrested from
custody.
Custody from 7 to. I am an old man of 80 years.
All right. All right. Let me think. Is the prosecution's case that the informant had entered into an agreement. So you are Vibhuti Bhushan.
No, I am Guru Charanaman. Vibhuti Bhushan is the informant.
Vibhuti Bhushan is informant.
My lord.
That the informant had entered into an agreement with the petitioner and others.
Yes.
Others were also party.
Others are witnesses.
But you are the person.
I have executed the agreement.
Then you must have taken the money.
No, money has been transferred in the name of different persons.
As per your direction. As per your direction.
No, he was aware that they were the co-sharers. They are witness to the agreement. Therefore, he has paid them, all of them separately.
The FIR is only against him.
No. FIR is
With the entered into an agreement with the informant.
Another bill application 2491 of
Sale a piece
24.
of land against which he had earlier paid a sum of rupees 63 lakh and subsequently 8,75,000. So stop. After having received the amount, the petitioner avoided to transfer the property by violating the conditions of the agreement. Oh, stop. Mr. Mohanty and senior counsel appearing on behalf of the petitioner has submitted that it's purely a civil dispute which has been given a color of criminal case by lodging the FIR. Stop. He has further submitted that in any case, the land sought to be purchased by the informant did not exclusively belong to this petitioner, rather to his co-sharers also.
His co-sharers who are witness to the agreement.
Co-sharers also who are the witnesses to the agreement to sale document. So he submits that keeping that in mind, the informant had paid different amounts to all the co-sharers through RTGS. Stop. An amount of rupees 16.
From a company, it has been transferred to me, not by the informant. In where he is said to be one of the directors.
Informant.
In which my nephew is a director from that company I have received the money. Not directly from the informant. Anyway, it is said that that is towards the my share. So that is 16 lakhs 20 I have
So,
received.
but how can you deposit that amount in his account?
Well,
How can you deposit that amount in the account of the informant?
1620 has come now from whichever source it comes. It doesn't matter. It comes.
No, you said that you received the amount from a company, not from the informant.
Wife of the informant is the director of that company, na? Company which has sent me that money, wife of the informant is a director of that company.
So he submits that
No dispute that I have received
to refund the said amount of rupees 16.71.
20.
16.21.
20 lakhs. That's 20,000. 16 lakhs 20,000.
16 lakh 20,000 to the informant. Full stop.
My lord, he has also filed a writ application that the land may not be to restrain the sub-register from executing any transaction relating to this property that is pending before this online. He should have come in for filing specific performance of the contract, but anyway, whatever his lawyer has advised.
Agreement in 2016. Maybe because all this year he has not done so. These are the
He is showing his bona fide, he is ready to.
One small clarification, my lord, the entire amount of transaction is 71 lakhs 75,000.
75, yes.
71 lakhs and 75,000.
What have I mentioned?
63.
63 lakh plus 8 lakh 75,000.
Sorry.
If you take it, will you give up a claim to the land? Informant comes down. Should be done.
So considering the fair stand taken on behalf of the petitioner, this application is allowed subject to the condition that the petitioner shall deposit the said amount of rupees 16 lakh
20,000.
20,000 in whose account?
I'll quote below. I'll put it in quote below. Because it is not known whether he will give up his.
Considering the fair stand taken on behalf of the petitioner, he is directed to be released on provisional bail. 10,000. Stop. The dispute is referred to Odisha High Court Mediation Center for a resolution of the dispute. Right. So your stand we have mentioned, we are not directing you to deposit. And then
I am ready to deposit, or if he takes, I am ready to refund him. I want to get out of it.
oh, go to the mediation center. Or tell you can deposit. When counsel for the petitioner is permitted to implead the informant as opposite party number 2. Informant as opposite party number 2. Add informant as opposite party number 2. High Court Mediation Center.
I may be permitted to correct the cause type.
Yes. Said corrections will be incorporated in the cause title of cause title in course of the day. Give there a cutting and.
Okay,
You will have to do that in the.
Consolidated cause title filed by tomorrow. And your lordship pleases to issue notice. Consolidated.
No, we are not issuing notice. Notice will be issued by the mediation center.
And tomorrow I'll file.
Cause title will be filed by tomorrow. The secretary, Orissa High Court Mediation Center, is directed to assign this dispute to a learned mediator soon after the reference is received by him. Stop. After issuance of notices to issuance of notice to opposite party number 2. He will do that, secretary. Stop. Unless this matter on 8 weeks.
Any date your lordship.
And in the meanwhile, if that 8 weeks.
May will be closing.
Along with any other bail application arising out of the same case.
Same PS.
Same PS case numbers. Arising with any bail application if filed arising out of. Yes, anything else?
No, trial court may be directed to release us provisionally. Terms and conditions.
10,000 something. No further question.
Item number 25.
Yes, my lord. Yeah, the petition in custody is 17/2/2024, my lord. Let's come to that. Annex 1, page 8. There's a case under section 408 IPC, my lord. Look at page 9 there, that lane portion. One Gaurav Agrawal is a proprietor of one Krishna Doers dealing with that household articles, and the present person was working as a manager under him.
So complaint case?
No, my lord. FIR, my lord.
FIR.
Yes, my lord.
So you said complainant.
Stated complaint.
Paragraph 2. All right.
Here, allegation is that the petition was posted as a manager in his shop, and he was supposed to pay rupees 10,000 per month. And besides the duty entrusted to him in the shop, he was sent to nearby vicinity for the purpose of supply of goods as well as collection of money. Since dispute arose for which this leading to lodging this FIR at under section 408 IPC, allegation is that I've collected some amount from the purchasers to the tune of 7,58,000. I have misappropriated the same, not deposited the same in the account of the. That is what dealing.
Is that permissible in law?
No, that is what the allegation is. But I posted I'm posted as a manager to look after the day-to-day business of the farm at Kantavanji in the district of Balangir. But I very often used to send different parts of in and around Kantavanji for supply of goods as well as for collection of money. That is what. But I have not been paid what was issued by the complainant. There is some dispute which leads to registration of the affair.
According to the prosecution's case, the petitioner was an employee of Gaurav Agrawal.
Yes, ma'am.
Comma, employee of the
No, Gaurav was the manager, he the owner. I am the manager. The petitioner is the manager.
which company?
That Krishna Duas.
Employee of Krishna Grover.
Duas.
Krishna
Duas, my lord.
Krishna Doers.
Yes, ma'am.
Krishna Doers. Stop. The a manager of the said firm has filed the FIR with an allegation that the petitioner had collected a sum of rupees 7,58,000 from various customers on behalf of the firm, which he did not deposit in the account of the firm and misappropriated the amount. This is the allegation.
That's the allegation.
Next, when counsel appearing on behalf of the petitioner has submitted that the case is triable by a magistrate. First off. Secondly, a false case has been lodged because of dispute between the firm and the petitioner in relation to payment of
Salary.
the petitioner's salary and other entitlements. Stop. Next. Considering the nature of accusation and the submission advanced on behalf of the petitioner as noted above, case is made out for grant of regular bail. This application is allowed.
Naturally.
Item number 26.
May I please your lordship? My lord, the petitioner is in custody since 5th February 2024, my lord. And he under section 305, my lord, of IPC, my lord. The prosecution story of the
What is 305?
30 abatement of suicide of a minor, my lord, or incest. Initially, FIR registered on a 306, thereafter on forwarding report, it was turned to 305 because the victim's age is 17 years, my lord.
Yes, madam.
There are allegations that we actually should stop this lady, girl, minor girl, and so force her to, open daylight manner in front of everybody. He has humiliated her, asking her why you don't love me, and probably tried to also outrage her modesty there in front of the villagers. And this out of this humiliation, this girl has taken poison and she succumbed to the died.
But my lord, as per FIR and rejection order, my lord, it is clearly he asked the deceased my lord why she loves him, my lord. Yes.
What transpires in the conversation that is not immaterial. Immaterial is that he has done something in public view which has humiliated the girl.
No, but abatement is not.
Because after that.
No, that is not abatement.
But after that, she has come home and then she has been asked by the family members why it was done.
Abatement means some positive act to assist, to help someone who intends to commit suicide. Then you take this, or if you do this, that is abatement.
Because of his act, she has not been able to pay the money and she has.
She might not have done that.
So that is why whatever you have to consider.
The allegation in the FIR against the petitioner is that because of the petitioners that the petitioner had attempted to outrage the modesty of the victim within public gaze and used to stalk her. So, out of social shame, the victim is said to have a minor, is said to have committed suicide. Stop. And counsel appearing on behalf of the petitioner has submitted that the allegation made in the FIR lacks essential ingredient of abatement to commit suicide. Stop. Next, learned public prosecutor has opposed the prayer for grant of regular bail. Stop. Next, be that as it may, I find substance in this submission made on behalf of the petitioner that there is no element of abatement in the prosecution's case as narrated in the first information report. Stop. This application is accordingly allowed.
Deeply obliged.
Item 27.
May I please? 379 and 511 and along with other offences, my lord, 15.2, 15.4 of the Petroleum Act, read with section 3 and 4 of the PDPP Act, my lord. My lord, it is only an attempt to commit theft of oil from the IOCL pipeline. It is only an attempt. They had not taken anything. An attempt was made by the petitioner along with others, and the petitioner was arrested for the said. All the offences are triable by magistrate. The petitioner is inside custody since 19/2/2024.
How many petitioners are there?
Only one is there before my lord.
So how many persons are involved?
My lord, the FIR is unknown, my lord. The FIR is unknown, but in the rejection order, if my lordship will peruse the rejection order, page 14.
What is PDPP?
My lord, that is Prevention of Destruction of Public Property Act.
Damage to public property.
Yes. And along with 379, 511 is there.
FIR was registered against him with the allegation of tampering the main pipeline by fixing unauthorized clamps for theft of petroleum oil.
Yes, ma'am. Petroleum.
Stop. The name of the petitioner emerged during the course of investigation.
Lordship.
And counsel appearing on behalf of the petitioner has submitted that what was recovered from your possession?
Nothing was recovered, my lord, because it was only an attempt. From the spot, my lord, they have recovered, the IO has recovered. Lordship may kindly peruse page 14, my lord. Page 14 towards the middle portion, my lord. I am reading it. My lord, further during the course of investigation, Lordship got it.
On behalf of the petitioner has submitted that though certain incriminating materials have been recovered
From the spot.
from other persons, from the possession of other persons.
No, my lord, from the spot by the IO, that is written there in the rejection order.
Please come to paragraph 4.
Yes, para 4 is that, my lord, but the observation given by the learned court below.
Forget you have mentioned, you have stated. How can you say no to it? And counsel for the petitioner has submitted that no incriminating material has been recovered from his possession, and his implication is based on confessional statement of co-accused persons recorded by the police while in custody. Stop. Next, considering the nature of accusation and the facts and circumstances, in my opinion, case is made out for grant of regular bail. This application is allowed.
Item number 28.
May I please, madam? The petitioner has been languishing inside the custody since 18 February 2024, being implicated in a case under section 395 IPC, that is section 25-27 of the Arms Act. The allegation is that on 18 February 2024, at about 3 a.m. to 3:30 a.m., while the informant victim Sheikh Ahmad Hussain was coming to his house situated in the city of Mauribhanj to Angul by his car, some unknown culprits restrained him on the way at some distance from Belda Ghat.
Let the case diary come.
So the certified copy of the FIR has to be.
FIR, why are you not filing FIR? FIR, first of all, file FIR for these.
Item 29.
Lord, alleged offense of 20B2C of NDPS Act. Lord, records will be necessary here. The reason being, Lord, eventually the petitioner is implicated here because he is owner of the motorcycle.
Owner of?
Owner of the motorcycle. Motorcycle we have exchanged since 2016 with the automobile store. The store person has not changed the ownership. I have got a new vehicle in exchange of that. Those records were taken before the court below. But if Lordship will see that motor vehicle agency, I mean that owner, they have not been examined by the police. Secondly, Lord, from possession, petitioner's possession, nothing has been seized. Petitioner, FIR is of 22. Petitioner arrested on the basis of the NBW in 2024. And interestingly, your Lordship will find Ajit Kahar, who is the person who...
What has been recovered?
Ganja of 25 kg, my lord.
From whose possession?
Lord, it is not from nobody's possession. That's the issue. That is why I say records should be necessary.
So what is there in the FIR?
FIR, they say 2 persons were coming through a motorcycle. When they encountered the motorcycle and the motorcycle fell down, those 2 persons they fled away from the spot inside the jungle. One of them, the police has identified as Ajit Kahar, who is yet to be apprehended. That Ajit Kahar is yet to be apprehended. This incident took place at Baud, my lord, Baud. And I am a...
And who were apprehended?
I was not apprehended. I am a motorcycle. I am the registered owner of that motorcycle.
Oh, forget.
I'm so sorry. I am so sorry, my lord. I could not.
The question is,
right, my lord.
When it comes to recovery of something from possession,
right, my lord.
It means from your possession. So if something is recovered from your motorcycle, your truck, your anything,
right.
So that must be in your conscious.
Must be under my, yes. That is that incident
is what I am trying to understand.
Correct.
So when the motorcycle was left by the motorcyclist,
right, Lord.
Thereafter, whether you were or what is there to show that the recovery was from your possession?
There is nothing.
That is the question.
There is nothing.
Motorcycle that was left behind there, the motorcycle is registered in his name.
So that is not his possession.
But then when I need to take instruction.
Already
regarding
seek
and for
instruction.
the CD.
4 weeks.
And also the criminal evidence.
No, police writes that there is no criminal incident. Kindly see that. Police himself writes. On investigation, police
may
writes,
correct themselves. Just seek instruction.
page 18.
As requested by learned public prosecutor, list this matter on 2 weeks so as to enable her to seek instructions.
Great.
Item number 30.
Please, Your Lordship. Item 30, my lord, I pray for short adjournment.
Why, sir?
On behalf of Mr. Das, my lord, he has some personal difficulty, my lord, out of state.
Let me
Tomorrow or
see.
next week, any day.
Let me see it. What is there, madam?
60 kilos, my lord, 60 kilos, 560 grams to the house of the petitioner.
I pray for tomorrow or next week, any date, my lord. Mr. Das is out of state.
As
On behalf.
requested on behalf of the petitioner, list this matter on 2 weeks. Yes.
Deeply obliged.